Support for the impact provided by
Washington's community and technical colleges are building the future of our state's economy. On average, our students earn back almost 3 times what they put in. That means that a student here can study for an in-demand field here and get a high-paying local job here, or here, or here. When it comes to the future of our economy, nothing matters more than filling Washington jobs with Washington residents. And no one is doing that better than Washington's community and technical colleges.
additional support provided by WSECU.
This week on The Impact.
Our state civil rights law is neutrally applied. If you engage in commerce, part of the bitter and sweet is that you're going to live by the laws.
The U.S. Supreme Court sides with a baker who refused to make a cake for a same-sex wedding. What does it mean for Washington?
Seem to be very willing to go ahead and create this religious exception to public accommodation laws.
Plus, a ballot title battle heads to court.
The term semi-automatic assault rifles, we believe, is perfectly appropriate here.
This ballot title needs to represent what people are really voting on.
And the surprising reversal of a controversial employee head tax. That's all coming up on The Impact.
From Olympia, an in-depth look at decisions at the state capitol and how they impact you. This is The Impact.
There is a difference, Your Honors, between a freedom to believe and a freedom to act.
A for-profit does not give up their constitutional rights by going into business. Otherwise, we would only have non-commercial art.
Hello and welcome to The Impact. I'm Mike McClanahan. Those were arguments from the Arlene's Flowers case before the Washington State Supreme Court. It centers on a florist who refused to provide flowers for a same-sex couple's wedding and was sued by the state attorney general and the couple for violating the state's anti-discrimination laws. A recent ruling from the U.S. Supreme Court in a similar case out of Colorado sided with a baker who refused to provide a cake for a same-sex couple's wedding. Both cases involve defendants arguing that their objections stem from sincerely held religious beliefs. What does that case mean for the Washington florist case? Joining us now to weigh in on the issues are Seattle University School of Law professor Brian Adamson and St. Martin's University Legal Studies professor Sean Newman. So first off, Professor Adamson, you teach First Amendment and media law. From your perspective, what implications does the Colorado case have for the Washington case?
Well, it was a very narrow ruling, this Supreme Court case in the Masterpiece Cake Shop litigation. And so its precedent for Arlene's Flowers is very limited in terms of its applicability. What it did affirm two things primarily, generally speaking. It affirmed the fact that gays and lesbians have a right to the same goods and services as other members of the community on an equal basis, and that generally applicable public accommodation laws and rules are seen to be effective and enforceable, even in the context of someone arguing to do so to provide certain goods or services would be against their religious beliefs. So it doesn't impact the effect of public accommodations laws. I think the other thing is that it's narrow. Other reason that it's a narrow and limited precedent for Arlene's Flowers is the fact that it turned on the way in which the Colorado Commission and then the Colorado Court of Appeals treated and talked about Philip's sincere religious beliefs, where we don't have that what they call hostility toward religious beliefs that the majority of the court seemed to feel that existed in the Masterpiece Cake Shop case. So it's limited, I think, in terms of its impact.
So, and I know, Professor Newman, you teach civil rights and also legal studies, and from the context of students, MBA students and that sort of thing, what does this case mean for business?
Well, I agree with Professor Adamson. It's a very narrow case. It's portrayed as a conflict between civil liberties and civil rights. But as Professor Adamson said, our state civil rights law is neutrally applied. If you engage in commerce, part of the bitter and sweet is that you're going to live by the laws, these neutral laws that prohibit discrimination based on protected status. I don't think a Masterpiece Cake case is going to be very beneficial for Arlene's Flowers. As Professor Adamson said, the Masterpiece Cake case had focused, the court focused on how the cake maker was discriminated against, or his beliefs were disparaged by the commission. You don't have that here in the Arlene's Flowers case. But it does present this interesting conflict between civil rights, which are primarily statutory, versus civil liberties, which are constitutionally based. But civil liberties are, constitutional rights are never absolute. They can be limited by, even if you view this as a targeting a particular religion, a compelling governmental interest can justify a statute that impinges on your fundamental constitutional rights.
So the Attorney General's office here in Washington issued a press release about the Colorado case, and the AG argues that he says that that decision may add some procedural steps to the Arlene's Flowers case, but will not alter its ultimate resolution. While the attorneys who represent Baronel Stutzman, the florist in question here, say that they disagree and say that that in Washington that the Attorney General sued the florist as a business owner and as an individual, but failed to prosecute a business that they say, quote, obscenely berated and discriminated against Christian customers, end quote. So do you think that those two, are there inconsistencies, incongruencies here? Or?
Yeah, well, let me just, before Professor Adamson jumps in, I think a couple of things. Remember, Arlene's Flowers was sued by the couple as well. Not, so that you have that added layer. And she was held individually liable under our state law against discrimination. Individuals can be held liable for violating our discrimination laws. So I don't agree with the attorneys for Arlene Flowers. I don't think it's in the record. We chatted about this. I don't think these other cases are in the record as they were in the Masterpiece case. There were a couple other cases where it's kind of set up, in my opinion. I was reading about how somebody went to a cake shop, wanted a baker to put a specific homophobic design on a cake, and the person said, I'm not going to do that. And they filed, and the Human Rights Commission didn't go after the baker.
Yeah, that's a great point, Professor, with regards to the disparate treatment that was alleged by the Christian customers. It's not in the record, doesn't seem to be in the record. Individuals have a right of action in these cases, in these public accommodation cases, so it's just not about what the Attorney General chose to pursue or not pursue. Two other points that bear mentioning. If the Supreme Court takes this case up, if they take Arlene's Flowers case up, they will likely want to visit the things that they scrupulously avoided in the cake shop case, and that is the free exercise issue, and whether or not cake making, or in Arlene's Flowers case, floral making is expressive behavior. If it is expressive behavior, then it is accorded a certain level of constitutional weight, where then the state may have to, in some circumstances, I won't say every circumstances, have to make some type of accommodation. Even generally applicable public accommodation laws may have to yield to some degree to one's expression of religious objection. That's what they didn't get to in Masterpiece Cake Shop. That's what certainly Jack Phillips, his attorneys, he wanted to get to, but the court cut that off. Even some of the justices, particularly Gorsuch and Justice Clarence Thomas, who concurred in Masterpiece Cake Shop, seemed to be very willing to go ahead and create this religious exception to public accommodation laws. So they may look at Arlene's Flowers as an opportunity to try to do that, or at least try to move the needle. It's doubtful whether they have five votes on the Supreme Court who are willing to do that. And then finally, quickly, with regards to the amicus case in the Masterpiece Cake Shop case, there were after the Colorado Civil Rights Commission had cited Jack Phillips for a violation, another person, Jack, can't think of his last name right now.
I don't know the guy.
He went to 3 bakers and asked for this cake with homophobic messages on it and an image, not homophobic, biblical message and homophobic image on it. Those bakers refused, 3 of them, and so the court, one of the bases of its ruling in favor, another basis of its ruling in favor of Phillips was the Supreme Court said that the Colorado Civil Rights Commission, in saying that those bakers had not violated that person's religious beliefs, that they were being inconsistent. They had treated Jack Phillips less favorably than they treated those bakers who refused to put homophobic images on a cake. And it raises a whole host of questions about the using testers, using individuals going to do testing to advance civil rights issues and causes. We see it all the time. But it was just a very unique thing that they chose to use that investigation and an amicus brief to support the position that they ended up overturning the Colorado Court of Appeals. So it was just a very curious thing, I thought.
I think that the key point is neutrality. You know, there's other cases that were brought up in the amicus. They said, hey, these people aren't being treated the same. The government has to treat everybody neutrally. So that was the trigger there. But I think it's important to note that, as Professor Adamson said, you know, what is speech? We have symbolic speech. Historically, nude dancing is speech. Wearing the flag is baking a wedding cake speech. Is preparing flowers speech. And if it is, as Professor Adamson said, there's a heightened protection given to that conduct. And that raises all kinds of issues.
Well, we're out of time, I'm afraid. We could probably talk about this forever, but again, I really appreciate your insight, and hopefully we will be able to revisit this issue in the future. Professor Adamson, Professor Newman, thanks for being here.
Thank you.
Still ahead, the dispute over a ballot title on a proposed gun-related initiative. But first, the scene at Seattle City Hall as the council reversed a controversial employee head tax less than a month after it was passed. That's up next after the break.
For complete coverage of the Washington State Legislature, live and unedited, on TV and online, turn to TVW.
7 in favor, 2 opposed.
Welcome back. In a stunning reversal, the Seattle City Council votes to repeal the controversial employee head tax it passed less than a month ago. A statement from the mayor and several council members said it was clear the tax on companies with more than $20 million in annual gross revenue would lead to a legal battle and detract from the effort it was intended to fund, reducing homelessness and creating affordable housing. The Tuesday 7-2 vote comes as opponents of the head tax were planning to deliver signatures for a referendum to repeal the measure. Grassroots organizers for that campaign and those who support the tax packed a special called meeting to weigh in. The controversy may not be over. Some supporters of the tax vowed to increase the pressure on city leaders. State lawmakers have also discussed bringing a new state law to prevent cities from passing similar taxes. In a victory for Washington state tribes, a split decision from the U.S. Supreme Court means the state must continue to fast-track the replacement of fish-blocking culverts. Justices deadlocked in a 4-4 tie, which means a lower court ruling remains in place. That ruling requires the state to pay billions of dollars to clear stream obstructions caused by culverts, pipes under roads, which can prevent salmon from migrating. In a statement, Northwest Indian Fisheries Commission Chair Lorraine Loomis says, quote, the Supreme Court has affirmed a common sense ruling that treaty rights require there to be fish available for harvest, end quote. State Attorney General Bob Ferguson brought the appeal, arguing that the ruling requires the state to fix culverts even when dams or federal culverts prevent salmon from ever reaching them. Ferguson issued a statement that included, quote, it is unfortunate that Washington state taxpayers will be shouldering all the responsibility for the federal government's faulty culvert design, end quote. Coming up next, the outcome of a battle title dispute for an initiative aimed at new gun restrictions.
concerns that we have about value judgments that may be loaded into certain words.
Might not provide enough direction to voters about what other issues we're going to be talking about here.
That's right after the break.
Get more from TVW. Follow us on Twitter at TVW News and find us on Facebook for exclusive content and more. Another way for you to connect with TVW.
Welcome back. What's in a name? Well, when it comes to ballot initiative titles, the law spells out how many words they can contain, what they must reflect, and what they must avoid. And even though we're just talking about a top line and a couple of paragraphs, finding consensus on the title can be anything but simple. To get an initiative to the people on the statewide ballot, you have to get nearly 260,000 signatures here to the Secretary of State's office. But before you can start collecting them, the ballot measure must have an official title. To get one, it winds up here at the State Attorney General's office. Their job is to find an accurate, unbiased title for the initiative and to give a brief description of what it does. But when people disagree with their choice of words, it winds up here in Thurston County Court. That's the case for Initiative 1639. Multiple parties challenged the ballot title and concise description provided by the AG's office. Pro-Second Amendment rights groups took issue with the wording and where the emphasis should be. Attorneys for the sponsors of the initiative also filed a challenge, requesting more specificity in the title while also responding to critics requesting broad changes. An attorney representing the sponsor offers this description of what I-1639 would change.
First, it creates new requirements that relate exclusively to the purchase and transfer of semi-automatic assault rifles. And it does this by requiring enhanced background checks, by requiring new age limits, and requiring safety training and waiting periods. And second, the initiative enacts new requirements that apply to all firearms. And most importantly here, it creates secure storage requirements that applies to all firearms.
The statement of subject chosen by the Attorney General's office was Initiative Measure Number 1639 Concerns Firearms. An attorney representing the NRA says that title is too vague and should read Concerns Restrictions on Firearms.
Saying that the statement of subject is about firearms, that's certainly broad enough, but we don't think it's precise enough. I don't think there can be any reasonable argument that this initiative, whether you're for it or against it, it's about restrictions and limitations on firearms. That's what it's about. And you know, they think it's a good idea. We think it's a bad idea. We're not here to debate that. Okay, but the fact is, what this initiative is about restrictions on firearms. So we think it is important for that to be in the title, and it's simply not sufficient to say, well, it's about firearms. It's about more than just firearms, right? It's about restrictions on firearms, and that's certainly been the way other initiatives have had similar titles. So we think that that's an important thing for the court to consider.
Some of the challengers are concerned there are loaded terms in the description of I-1639 that could bias voters.
I think we're all here working in sort of a inspiring way to get objective notice out to the voters, right, to what is important for them. And I think the key, and I can sort of hear the theme developing just from the court's remarks so far, is we're trying to avoid value judgments, right? We're trying to avoid any sort of foreshadowing what we think is important, or we're just trying to lay the facts out as objectively as we can so the voters can decide. And so the points that I'm here to make, I think, largely sort of fall into concerns that we have about value judgments that may be loaded into certain words.
Attorney Steve Fogg objects to the AG's choice of words in the phrase enhanced background checks from the description.
In terms of the concise statement, we do think and are very strongly opposed to the use of enhanced. And I think that gets at exactly what we're talking about. I mean, enhanced is a value judgment. And you can look at Webster's and say, well, no, enhanced doesn't necessarily mean better. But I think most people, when they hear about something being enhanced, they think it's an improvement.
Some of the challengers also argue that the initiative would create a tax on gun ownership because it would allow the Department of Licensing to charge up to $25 for administrative costs related to certain firearm purchases. Supporters of the initiative dispute that characterization, describing the cost as a fee and a minor aspect of the overall ballot measure.
And the argument here is that that in theory it's going to be dedicated to a certain administrative cost associated with the program, and that's been the argument that they've had overall. I still believe these are taxes on ownership, and especially when we're applying a tax to something that's a fundamental civil right for somebody to have. We have to recognize this is still a civil right. The Second Amendment is still as much a part of the Constitution as the First Amendment is, or the Fourth, or the Fifth, or any others.
In a legal brief, opponent Glenn Morgan argues the description should refer to restrictions on semi-automatic rifles, but leave out the phrase assault rifles altogether, calling that an inaccurate and emotionally biased political term of art.
The term semi-automatic assault rifles, we believe, is perfectly appropriate here. It's a commonly used term. It's a term that's been used in federal law for over 20 years. It's a term that's been used in Washington courts for some time. It's a term that the public is generally familiar with. And again, what we should be focused on here is giving the public a heads up about what type of weapons, what type of firearms are we dealing with. And we believe when the voters see semi-automatic assault rifles, they're going to know specifically the types of weapons that are used here.
Some challengers also think there should be more focus placed on the implications for all gun owners under the secure storage provision of the initiative. Challenger Joe Wilson argues the statement of subject is, quote, misleading, inaccurate, and not impartial, and should be changed to read, Initiative Measure Number 1639 concerns taxes and individual rights, end quote.
So the people in this state, when they vote on this issue, they need to know that in this initiative, rights are being given up. Because if you read Article 1, Section 24 of our Constitution, it says that the right to bear arms shall not be impaired. The National Conference of State Legislatures, they said that ballot titles are very important because a lot of people don't read the initiative. All they read is the ballot title. And this ballot title needs to represent what people are really voting on.
That statement of subject has to be sufficiently broad to encompass every aspect of the initiative. This does more than restrict access to firearms. Most particularly, it also includes additional criminal provisions. When individuals' liberty in the community is at stake, a criminal provision is very important, and I think that it may well jeopardize the legality of the measure were it enacted to have a statement of subject that is too narrow to encompass that criminal provision. In addition, a narrow statement of subject as offered by the three parties would not include the fact that a fee would be permitted, not mandated but allowed. Two of the options included the word taxes.
The Attorney General has reportedly openly endorsed the initiative and sponsored similar legislation in previous years. That leaves some opponents of the ballot measure language raising questions about the process.
Some states allow where both sides can write the ballot title. In this state, the Attorney General does it. And this court and this challenge is where we have the opportunity to have all sides. And what we have here today is a ballot title that has been written by the Office of the Attorney General after, I believe, he endorsed the initiative. And to me, that puts a cloud, a big cloud on this ballot title as far as being impartial. And I'm hoping today that we can remove that cloud, that we can create a ballot title that is not just using the words from the political campaign, but represents all parties. And in the eyes of the voters of this state, will see that it is impartial.
I want to start by explaining the role of the Attorney General's office. I think that would be helpful for those in the courtroom to understand. The Attorney General is an elected official who does declare a party, unlike a judge who does not. That has always been the case. And despite that, the Attorney General's office is charged with representing agency decisions, with defending the law, and with writing ballot titles. We're statutorily responsible for doing that. And in this particular case, the Attorney General did not direct how this ballot title was written. I don't know if he has endorsed this measure. He certainly has taken positions on gun control in the past, but he was not personally involved in this, and I have never received direct instruction from an Attorney General on the wording of a ballot title. That said, in all things, the Attorney General strives to comply with the law, and the law requires an unbiased ballot title be written, and the law also provides this court proceeding so that this court may allow individuals to object to the ballot title and make a decision about whether appropriate wording has been used. So due process has been protected. All individuals have been given an opportunity to object. And in fact, we have a hearty objection here from 4 different parties, which I think is an excellent demonstration that the system is working and that the court is provided with all viewpoints and an opportunity to assure that the voters are provided the unbiased ballot title that they are entitled to.
The court has found that some of the language that was initially included in the title isn't as neutral as it should be. And I mean no disrespect to the Attorney General in formulating this ballot title. The court at this time is ordering the modification that we have been talking about.
Ultimately, the judge made a couple of changes to the description and summary, replacing the phrase enhanced background checks with increased background checks, and changing certain storage to non-compliant storage. The phrase semi-automatic assault rifles is still in the description and summary, and no changes were made to the statement of subject. The judge's ruling is final, so the title for I-1639 is now set in stone. Signature gatherers have just under a month to find 250,000 supporters to sign off. That's a wrap for this week's episode. We hope you'll join us next week for more in-depth interviews you won't find anywhere else. Until then, I'm Mike McClanahan. Take it easy.
Support for the impact provided by
WSCCU was founded by public employees, and since 1957 we've been returning the favor and honoring them. We're here today at Public Service Recognition Week. This is one of the ways that we give back not only to our members, but also all public employees who make Washington such a great state to live in.
Additional support provided by Washington's community and technical colleges.